All right.
All right. Well, welcome everyone. My name is Emily Raby. I'm with Lincoln County Regional Planning Commission.
And I'm Max Johnson. I'm the senior planner with Midcoast Council of Governments.
And I'm Laura Graziano. I'm the assistant county planner and GIS coordinator with Lincoln County Regional Planning Commission.
So I am just going to share my screen. Post needs to allow me to.
So picky that you have that. All right, you should have that.
Okay, great.
Wouldn't be a workshop if we didn't have technical difficulties.
Of course not. Wouldn't be Zoom if there weren't technical difficulties.
Right.
Exactly.
Okay. So welcome. Hey, girl. So we, McCog and Lincoln County RPC have been doing a series of workshops over the past year. We try and do one once a quarter. Past workshops have been LD 2003. One has just been, the role of planning boards and the work planning boards do. And so this one we thought is going to be, about subdivisions. So Max and I don't claim to know everything. We were even joking before this started that we work with planners around the state who have 40 years of experience and say they don't know subdivision law. So, we're hoping that this can be used as kind of a subdivision 101 primer for planning boards as well as newish town planners or those that are looking for a refresher course. So the first topic is just what is a subdivision? So we have a definition up on the screen for you that just comes from state statute. And it's the division of a tract or parcel of land into 3 or more lots within any 5-year period, beginning on or after September 23rd, 1971. This also includes the division of a new structure on a tract or parcel of land into 3 or more dwelling units within a 5-year period, the construction or placement of 3 or more dwelling units on a single tract or parcel of land, and the division of an existing structure or structures previously used for commercial or industrial use into 3 or more dwelling units within a 5-year period. The state has mandated that towns may not adopt a definition that expands this definition. However, it is the state, so there's also the caveat that they put that requirement in I think it was 2018. So if you as a municipality filed your previous definition with the County Registry of Deeds by June 30th, 2018, your definition would remain valid at the municipal level.
Question. Who has filed in Lincoln County?
That I didn't research this morning because I just found that little caveat about an hour and a half ago. So I can look, but this is where the definition that we have on the screen is the most recent definition of subdivision per state statute.
Thank you.
And they did that in 2018, Emily?
Yes.
So our subdivision ordinance that was enacted in 2002.
Hasn't been updated? Okay.
Yeah.
Okay. So I will do my homework a little bit to see who might have registered theirs with the Registry of Deeds. I don't know that this definition has really changed prior to 2018. It's more that you can't adopt a definition that would expand this. So for example, you can't then adopt the definition that says a subdivision's a tract of, 2 lots versus the 3. Or that a subdivision, I'm trying to think of another example off the top of my head.
And we'll go through some exceptions later, but maybe you have your definition saying it's only focusing on the splitting of the lot, but not having the multiple buildings on there or things like that. You have the state standard definition right here, and just whether you change that much is something that the state doesn't really want.
Quick follow on.
So
We're also going to have questions throughout this too. We're going to take breaks. So.
right, we're going to have like mini question periods after, like Emily will go through 4 quick slides, then we'll have a quick question and answer period for what we just talked, and then we'll have the big question and answer period at the end as well.
This was LD 2003. It was that in the 6 subdivision.
We'll save that one for, let's not dive into 2003 yet.
Okay, sorry.
It'll probably be at the big Q&A at the end.
Right.
I think I know what your question's going to be, and I might have an answer right for that. Now we have something to look forward to at the end.
It was inevitable.
LD 2003
You
is not
would've
big
been
for
right.
last year. All right.
So when do you start counting? Max put together, hopefully some helpful visuals to go with this, but the first dividing of a parcel creates 2 lots. The next division of one of the 2 lots, regardless of who subdivides it, creates that 3rd lot that would trigger subdivision review. If the subdivider is retaining one of the lots that they have used for their primary residence and have been there for at least 5 years before the split, then it would not count towards the subdivision. If that initial split, so the 1 to the 1 to 2, took place at more than 5 years ago, it would no longer count towards the subdivision process. So it would kind of reset the clock, if you will. State statute sections 4401 and 4402 outline a number of exemptions, which we'll get into in a few minutes. But if the town can demonstrate that unless the town can demonstrate that the intent of the developer is to avoid subdivision review. So if he or she is trying to find a loophole, that the exemptions would not be in place. Nope, that's okay, go ahead.
So the review has to make that determination. The reviewing board makes the determination as to the intent of the developer.
Yeah, yes, I mean, it would go to the planning board, especially, if the code enforcement officer he or she becomes the code enforcement officer, that person at the municipality would be making that determination.
We'll go over that when we get to the process itself.
We're so anxious.
We appreciate the interest
I
here.
didn't anticipate so many people to be excited about subdivisions.
Incensed?
Good work.
So what doesn't count as a subdivision? So if it's a division that's accomplished by, through will and testament or condemnation or an order of the court, those wouldn't count. Same for if the division was gifted to a person related by the donor. So say I owned a piece of land and I donated it or split it off to my child or my husband, that would not count. However, it must be held by the relative for a period of 5 years before a sale or split may occur. So it's not like you could sell it to your child and they can immediately turn around and re-subdivide. It also would not count as a subdivision if the division was accomplished by a gift to a municipality, and the municipality would have to accept the gift as part of that. Same with if you were dividing property to transfer to an abutting landowner. So that does not create additional lots. So really you're moving a lot line, if you will, or merging lots. That would not count. And then finally, if it's a division of a tract or parcel upon which lots contain permanent dwelling structures that legally existed prior to September 23rd, 1971, it would not count for subdivision. A few other notable exceptions to keep in mind is that a municipality could include in their subdivision ordinance, should they choose to, that a lot of 40 acres or more can be exempt from subdivision review. The land, though, must be located entirely outside any identified shoreland zone area. Another is that subdivisions that have been in violation for at least 20 years automatically become exempt, but until then, lots would be subject to subdivision review. And then finally, as of July 1st, 2018, the division of any new or existing structure into 3 or more dwelling units is no longer subject to subdivision review, meaning that apartments only go through a municipal site plan review process versus subdivision. So at this point, this is kind of our first break. I'm going to stop sharing my screen so we can also respond to questions from those on Zoom. How are we feeling so far? Questions?
I just have a quick question, and I apologize. I'm actually in my car today. So my question is, will this information, what the slideshow that you're showing, will that be able to be shared?
Yes, we're recording this, and we'll put the entire workshop online, both with McCog and Lincoln County RPC, and we can share the slide deck as well.
Great, thank you so much.
Emily?
Anyone else? Yes, well.
Emily? Yeah, in answer to, I think it was Mal's question, Bremen's ordinance says 4 lots, and that was adopted in 2012. We are out of date, I guess.
Do you remember when your ordinance was last updated?
Never.
Okay. That's fair.
I think that's a common thread.
I think so. I don't think you're alone, Walt. Are there any other questions at this point in the room or on Zoom?
The 3 is the minimum. You can't regulate 2, but you could regulate more.
Yes, 3 or more. Yep, so 3 is that minimum number.
You couldn't do 4 or more.
No, you could do it just means that if I split the land in 2, it's not going through a subdivision process. But if it's 3, 4, 5, I have a 12-lot subdivision coming up in Waldeboro. All of those would go through a subdivision process.
All right, so it's the minimum, yeah. got it.
It's meant.
Thank you.
Mel?
If sales to a corporation enter the picture, does that reset the count? In other words, if somebody divides parcel into 2 pieces, subdivision, that doesn't trigger subdivision, but owned by the original owner, 2 separate corporations, do you now have the ability of having 4? Or in other words, as you enter other legal entities into the chain, does it change count, the potential count?
So I want to make sure I understand your question. So say Mal Carey owns 100 acre. Well, let's go less than that. Let's say 10 acres. You split it into 2 lots. So Mal
Let's
Carey.
go for a larger amount of land.
Let's go.
Okay. Okay.
Let's go on.
So let's do 100 acres. You own a parcel of land that's 100 acres. You Mal Carey. You subdivide, so split it into 2. So now you have 2 lots that are 50 acres apiece.
And they're sold to 2 corporations that I
So you
control.
sold both. Oh, so you control both. So it's Mal Carey LLC and MC LLC.
Sure.
Okay.
And
then you're saying, and then they subdivide again, or just the
Well,
change of ownership?
In other words, does my original limit constrain those corporations' behavior? Or are they independent actors at this point?
So the 5-year trigger, it doesn't matter who owns it. It's always, it runs with the land. So if
Right.
you subdivided and you changed your ownership to an LLC or just sold them outright, they would still, if they were to subdivide again within 5 years, so now going from 2 to 4,
Okay.
I believe that they would be going for subdivision review. Because it's
So
within
it
the
does-
5-year
So it
period.
does not cascade with, well, the obligations do cascade from the original. Okay, yep, thank you.
because you've made the split and you don't live on either of those 2 properties.
Correct.
Yeah, so.
Corporations don't live anywhere.
So we have, Bruce, I'll get to you in just a minute. I know Michael's had his hand raised. Mike, do you want to ask your question?
Yeah, thank you. I have a question kind of about that minimum of 3. Does a municipality have to regulate subdivision? And could a municipality choose to say subdivision creating 5 or more parcels in 5 years is the limit? So like if you created 3 or 4 within that 5-year period, the municipality wouldn't have to regulate it. I guess, could you be less strict?
So like create a 2-tier system? Is that what you're, like 3 or 4, because the 3 lots is a state definition, so that's why you can't really change it to 5. But are you asking if like the code enforcement officer could do these standards for 3 and 4 lot subdivisions, and 5 and higher go to the planning board?
Yeah, and yes, assuming there's different standards for 3 or 4, or less than 10 or less than 20, whatever you want to make it. Could you have different standards for that? Basically, looser standards for a different amount under 5.
You're hoping to like expedite the process, if you will, for the applicant's behalf, to try and make the subdivision review process go faster?
Yeah,
Or have
or
less
just
work.
less. Yeah, basically like, yes.
We have two-tier review at Booth Bay. We have 4 and less is one level of review, and 5 and more is a more strict level of review.
Yeah, I think I mean, we'd
That's
probably
state
be,
law.
well, we'd be going over this through the process portion anyways, but the focus is just to make sure that you still have a process that's going over some of the things that the state does want you to review. I think this is the famous saying I always love to say during the planning board meetings as well. We're also not your legal representatives as well, so if you are making any ordinance changes of that type, and especially for subdivision, I think that you can certainly have that two-tier system, as pointed out in the audience, but you want to make sure that your attorney would be fine with that as well, because the attorney is the one who spend it.
Yeah, Bremen
Well,
has a
that's the way ours is,
Well,
minor and major.
yes.
Yeah,
But I'm saying just.
that's what we have in Bremen. We have a
Make sure-
two-tier system. Yeah.
And so I guess the question that I would have is, what do you have to regulate for, at a minimum, for the subdivision? Like, what's the minimum stuff that you have to regulate if someone's dividing one lot into 4 and you're saying that's minor and.
We'll be going over that in just a
Yeah.
moment when we go over what the process is.
Glad everyone's so excited about subdivisions.
Right now, the questions are more of what a subdivision is right now and what exemptions
And
are.
on that, so you put up the new definition. So under a subdivision ordinance, like the shoreline ordinance, we can make it, what's the word, more stringent than state law,
But not less stringent.
but not less. But what you put up there in the little notation at the bottom is, we have to do what the state says. We can't
Yeah, I can pull up that
add
slide
more
again.
to that definition.
I'm just gonna pull that slide up so we're all referencing. Yeah, for subdivision, they don't want you to change the definition. Here, I'm just gonna go back to it.
The definition of lease, a subdivision.
For subdivision, right? So it's a little bit different than like if you're, my favorite LD 2003 says you can be, less stringent on that one. Like you have to follow the guidelines, but you could accommodate for more units, for example. Like you can make some changes. For subdivision, they don't really want you messing with this definition at all. So when it says, that you can't adopt a definition that expands on this, it's either, my understanding is it's either you can't go more stringent or less stringent. You really just have to adopt this definition outright. Bruce, I saw your hand up.
Suppose Bruce owns 15 acres of land and sells lot 1 to Emily, sells her 5 acres, sells you 5 acres, and has the remaining 5 acres as open space. Is that a subdivision?
I assume you don't live on that
I
5 acres.
don't. No, Bruce doesn't live there.
Bruce doesn't.
So Bruce moves away because you're not staying in your house that was on
Well,
one of the
no.
lots. Or
This is an empty 15
Oh,
acre
empty
lot.
15.
Empty
Okay.
15 acres.
then yeah, it would.
Still counts as.
Yeah, because
I'm
you're
looking at
making
lots
three
subdivision.
lots, right?
Yeah.
Even if it's not going to go to up for sale, and it means a conservation easement, it's its own property.
Thank you.
Sure. Are there any other questions, or should we continue on? I am gonna share this. Oh, I saw Sky.
Hi, sorry. I was wondering if you could expand a little bit more on what you mentioned about the apartments being an exemption. I hadn't heard of that and I just was a little confused by it. And if you had anything more to say on that, I'd appreciate it.
Yeah, so I don't know the exact year the statute was passed, but as of July 1st, 2018, if any new or existing structure that is split into 3 or more dwelling units does not go through a subdivision review process. Before 2018 or before July 1st, 2018, apartment buildings were subject to subdivision review, but now it's not. So it's a law that a lot of towns, I start to realize, we're not aware of that And so that's one of the reasons I really wanted to also do this subdivision workshop with people, because it's a good way of getting this out there. But was there a specific question you had about that?
Yeah, I was curious about it, and then I was looking on the Maine state legislature about it and wasn't seeing it. But could you repeat what you said, what was passed in 2018, so I can look into it a little bit?
Well, I don't know the statute itself, but I think it's under section 4402 of the statute.
Awesome. And so is there any way in which, is it just apartments, or is it all multifamily buildings? Or is there any way that, like, if a developer came in and wanted to put in a multifamily building, it would still be under subdivision? Or is it pretty blanket towards multifamily buildings not having to do that now?
Blanket multifamily dwellings, unfortunately.
So it would include condos.
Condos, apartments, if they're dwelling units, they would still fall under whatever your town regulates for multifamily dwellings. So if it still goes to the planning board as a site plan review, it still goes to the planning board for site plan. But you don't have it go through a subdivision.
Michael, I see your hands up.
Yeah. So I've got a situation where one of the towns I'm working in does still have dwelling units as the ordinance still applies, subdivision ordinance still applies to creation of 3 or more units in a new or existing building. That would seem to expand the subdivision, the definition of subdivision regulation as the state currently has it. And the state currently says you may not expand the ordinance. So I'm assuming that besides needing to be fixed is kind of, maybe this is a question for an attorney, but is a problem. It would conflict
When
with
you're
the
saying-
current ordinance or the current state statute.
So when you're saying dwelling units, I mean, the current subdivision definition does say splitting the land into 3 or more dwelling units, or attractive land into 3, or creating 3 new dwelling units on the site. This is just a single building that,
right,
if you were to put the dwelling units inside that one building. So when you're saying the ordinance you're talking about, is this a plot of land that 3 dwelling units are on, or where one building just has 3 dwelling units inside of it?
It basically, our ordinance specifically says it applies to multifamily. Well, it says division of structures into 3 or more dwelling units. So that seems like it would be an expansion of the state statute, which seems like it says it doesn't want.
That would just have to be removed in your next.
Gotta fix that. Yep. Okay.
Can I go back to my example again
Yeah.
for a second? Suppose that Bruce doesn't live on the 5 acres of open space, but Bruce still owns the 5 acres of open space.
Mhm.
Is it still a subdivision?
Because you haven't been living on there for 5 years.
Mm-hmm.
Yeah.
Right. We can start getting on the next part.
I'm just going to share screen again and get to the right slide. Yes.
Now-
Got a bit of a lag.
That's fine.
Okay.
All right, so now we'll get into the actual process of it. And we touched on this a bit already, but subdivisions must be approved by the local planning board unless your local bylaws or ordinance states otherwise for a different process. We've already talked about having 2 different tiers, one for the minor subdivisions and some for the major subdivisions. As long as you have that in your ordinance, that's fine. But again, make sure you talk with your attorney about that so that you do have it consistent throughout. You should keep in mind that the subdivision law was created to help protect the consumers and prevent overdevelopment near wildlife habitats and wetlands. So that's sort of the one big golden thing you should keep in mind for what you should be focusing on when you're doing these subdivision reviews, and we're going to go over the review criteria later. This process can take months to complete, depending on the time to get land surveys done, contractors, and how frequently you meet for your planning board meetings. Doesn't mean it's going to take a whole year or half a year. you might have someone who has everything all set by month 1. And then you just get everything done in the next 1 or 2 meetings. There are 3 usual steps. There's the pre-application phase, preliminary, and final stages. Towns are not allowed to have more than those 3 stages. It's usually just simple how those 3 will go. If the subdivision crosses municipal boundaries, there should be a joint meeting between the 2 municipalities or multiple municipal authorities to review the application unless a waiver is granted. This is a rare case that happens, but
So who grants the waiver?
that would have to be decided. This would be in a pre-application essentially, where let's say Newcastle and Damerscott, just because someone's here from there, few people are here from there. Let's say that there was a subdivision proposal right on the border of Newcastle and Damerscott. The Newcastle and the Damerscott planning boards would come together for the pre-application and decide if they want to have a waiver so that Newcastle would review the subdivision on their own at their own time and Damerscott would do it on their own time. Or if during the pre-application they decide, we can easily get this done together, our meetings are around the same time, let's just plan meetings together. So that would have to be decided on by the municipalities that have to review that subdivision together in a public setting.
So would it be one subdivision application, or do you have to apply to both towns?
It would be something you kind of have to have filed with both towns, but it's really one application, you just have to give it to both towns.
Okay.
So the binding is with the deeded fee, not with the portion in a given town.
Well, the joint applications are also a bit more difficult for me to get because I don't know if it's just road running through one town that's then gonna.
Well, the example has a river running through it.
Fine, we'll do Damerscott and Nobleboro. Damerscott and Nobleboro. How about that for an example? I mean, it's going to be a case by case depending on what the subdivision looks like. I'll use Damerscott and Nobleboro just so we don't have a floating subdivision in the middle of the river. If the road starts in Damerscott but then ends in Nobleboro where the lots actually start to split up, it still does need to go through Nobleboro, and so you need to get permits through there. But there might be one lot that's in Nobleboro. It's a different case by case. I can't really give a concrete answer for right now.
Thank you.
Can say one town says it's only part of one lot is going to be on us and not even much of that. Can they waive their review entirely and leave it to the other town?
That would be something you can go over during the pre-application.
Yes, so they can do that.
Yeah. So then moving on. Notices. For those who were at the planning board workshop meeting, you may remember that there aren't really that many strict requirements for notices when you're doing the regular site plan, but there are state requirements when it comes to subdivision process. When the application has been filed, advertisements must go out to the applicant and to your local newspaper. And state law 38 MRSA 4403, that outlines your public hearing requirements as well. So if you just need, so if you are curious about it, it is available on the state for you to review. Your public hearing notice must include the date, time, location of the public hearing, and must be published at least twice in a local newspaper. The first publication must be at least 7 days prior to the public hearing. So if you have your meeting on Thursday, your newspaper is advertised on a Thursday, you want to make sure you have that first one at least a week prior, and then you can have the second advertisement done the day of that planning board meeting, because you've had the 7 day notice. But you can also probably do one 14 days ahead if you just want to be careful about that. And some people are a bit touchy when it comes to subdivision, so maybe get as much notice as possible. Those that abut the property under subdivision review must receive a notice in the mail. Town should keep a list and record of the letters that were sent out. And if someone does not receive a letter, that does not necessarily stop the process. We'll probably have someone who comes in and says, well, I was at this house instead of that house. I didn't get this much notice. Well, as long as you have the record that shows that you did send out the letters and you had reason to send it out to that letter, let's say your tax maps say person A lives at this address, this is their mailing address, and you sent it to there, but this person just never updated it. That's really not your fault. That was the person who didn't update their tax records. And if the subdivision is located within a source water protection area, the water company must also receive a letter of advertisement. This is just out of concern about the simple water source that's going to be impacted by the division, by the subdivision. Next, for the pre-application, this is where you just get an idea and a concept, and there's no real firm commitments except the joint waiver that we talked about just a moment ago. The applicant is mostly just getting opinion from the planning board before committing to any major expenses that they'll have to do, like getting a land surveyor, getting a soil scientist, or other type of individual who might be needed. And planning boards and the public should not anticipate all questions will be answered. I had a subdivision very recently where someone was wondering how the trash was going to be picked up for a place that was in the middle of nowhere, which we all kind of shrugged and said, how do you expect that to be done when there's no lots even being sold yet? A site map should be provided to show the lot divisions, any wetlands, usually identified by beginning with habitat, as well as the utilities that are there, any potential road access, whether that's going to be private or public, the boundary lines, and any other notable items that the planning board might think is important, or what you would have in your outline process. The site map does not have to be done by a professional at this time. Some people can just do a general hand scratch drawing. It doesn't have to be like an engineered land survey thing. As long as you can identify, as long as you can show all those items I just mentioned up there, it can just be something that the applicant could probably just do that day when you tell them you need a site map. And the applicant may provide as much material as they'd like to share at that time. You may have a minimum, but you might have very enthusiastic individuals who, as I say, they might have already hired the contractor, they might have already done the land survey, you want to show as much as they can. That's certainly fine, but you should have your minimum, allow them to present what they'd like at the time. Is that where we're stopping for questions first?
Yeah, so we'll take another question break. So I'm going to stop sharing my screen.
I think Marianne sent something.
So Marianne in the chat asked, although it was not a subdivision, the proposed solar farm off Route 1 in Nobleboro and Damascata had to submit a full application to both towns and receive approval from both towns' planning boards. Thank you for that, Marianne. So do we have any questions? Amy?
So, yeah, and of course, slippery slope.
It always is.
You have no idea how many times a week that I say, I can't tell you what you can do with your property. We act as a quorum, there's no application before us. Isn't that doing the same thing, where there's no application technically before us?
So the pre-application, it's not committing you to anything. It's more of a meet and greet, if you will. So it would be at a planning board meeting. So, it would be on an agenda that would be, put on the town website. And applicants can come and it gives them an opportunity to ask questions, to say, here's what we're thinking. We're looking at, 7 lots. Each lot is going to be X number of acres. And we just want to understand, your subdivision requirements require X, Y, and Z. I just want to make sure that I'm going to be submitting you this, and do you need that? So it gives the applicant a chance to ask a lot of process questions of the full board, and also for you to ask questions of the applicant. So, or give them, helpful hints, if you will. Like, we're gonna, if you have a precedent of, I don't know what it would be, but that you've never waived, one particular requirement, say, don't bother asking for a waiver on that. We are going to make sure that you submit that piece, for example. So it's more of a conversation-based pre-application, that you're not, other than the, we're setting aside the waiver between the two towns piece, that would be something that's more set in stone. But for the other types, that pre-application process is going to really be more a chance for you to become familiar with the project as a planning board, and for the applicant to ask you a bunch of questions, so that when they come to file something, hopefully it is a more complete application than them just walking off the street and not having that conversation with you.
Okay, so technically, we're not acting on anything.
Right, you're not granting waivers, you're not voting on anything, it's just an introduction to the project. Walt, I see your hand up.
To answer that question, we went through the process about a year ago, and the process is spelled out in the ordinance. So I think you're safe in having that preliminary discussion, because that is, as I say, delineated in the ordinance. The question I had was, what was the MRS citation for that 3-lot number?
Oh, for this,
4401, I think it was.
wait, for what a subdivision is?
What the 3-lot? Yeah, the 3-lot business.
Oh, that's, yeah, 4401, that's the definitions.
Okay. Thank you.
Do we have other questions in the room or on Zoom? Yes.
Yes, Ralph Norwood from South Bristol also. I was on the board some years ago. We had an applicant in South Bristol, and also he had a subdivision in Bristol. Now, common sense tells most people that you should have a connecting road to both subdivisions for emergency cases. Can a town request that, force that?
So the two subdivisions, they were separate subdivisions, but they abutted one another?
Yes,
Oh,
same
that's an
landowner.
interesting one.
And we have several lots like that, and with this LD 2003, I think we're gonna see more.
Well, that would be something that you can require. You just have to make sure that it's in your ordinance for how you're referring to that. I think some towns already have road requirements to be at a certain width so that emergency vehicles can get there as well. And that would be something to also bring up at the pre-application as well. You might just notice that, and even if it's not in the actual ordinance itself, just say, as you said, common sense would say, why not just have this so that the fire emergency is a lot easier to get there, because then everybody wins. And that would be something that they may not have thought of during the pre-application part, and incorporate into the preliminary, even if it's not actually required at that time. But it's, again, something that you would just give your perspective to, even if it's not in the ordinance itself. But you can enforce it if you do put it in the ordinance.
But it was also done so it didn't fall under, it fell under minor subdivisions in each town. Yeah.
And was that, again, I can't speak for everyone's ordinances on that. So I guess I would just say, is that the same process you have for minor subdivision as you have, other than the municipal authority, planning board versus code enforcement officer, are the standards and the items that you're asking for in these different in those cases?
Yes, there are several differences between minor and major.
I wonder if one of the towns could have waived their authority and it would have been a major under the other towns. What?
Town line, probably separate ownership if he was smart.
Yeah, probably.
Back to LLC 1 and LLC 2.
Right.
But by the way, the DEP doesn't recognize that. They don't recognize personally held LLCs as separate ownership.
Yeah. Nice try, Mal LLC and MC LLC. Yeah, for cases like that, I think we'd have to just look into how we would specifically done. But personally, I always, even if you have the minor and the major subdivision process, I'd still make sure you have almost the same standards on both of them so that it's still applied to both of them. But I can't speak for what your ordinances say specifically.
I recall one at Booth Bay many, many years ago where same developer, 2 subdivisions that abutted. And my recollection is we asked him to connect them and he said, I won't. Because I don't want the extra traffic going through one subdivision to get to the other subdivision. It's a 15-year-old recollection, so it may be wrong. But
I've seen cases in that scenario where there's a gate that can be opened in emergency.
so we didn't think about that at that time, but yeah, he was adamant about not connecting the 2 subdivisions.
We requested in the South Bristol side, a pond in a wet area for fire at that time. And whereas the Bristol side did not have that water. So that's another scenario that would work if they were joined.
Was that part of your ordinance?
Yes, it is, I believe so. Requesting the fire department. Yep. In South Bristol.
Are there any other questions for those attending by Zoom? Okay, so I'm gonna share screen again, and we'll go through the next few slides. Okay, there we go. So now, once your applicant has filed an application, they've had their pre-submission meeting with you as a planning board, and now they've submitted actual documents for subdivision review. So this is kind of stage 2, if you will, is the preliminary review. And the best equivalent we could use as an example is like, it's the equivalent to site plans for most planning boards, because the applicant's going to have roughly 90% of, or, you know, a good amount of what is going to be shown on the final plan is going to have to be on this one. So commonly required items would include, you know, that it's a land survey done by a certified professional planner, that they have done soil testing and show potential locations for subsurface systems. They have the number of acres for each lot. They're showing where wetlands is, and calculating out that, you know, the wetlands square footage separate from, you know, the upland acreage, if you will. They have stormwater management plans and soil erosion control measures in place. They've already obtained their letter from the Maine State Historic Office regarding historic impact. They'll have some sort of road or easement plan, as well as should be identifying, you know, is it going to be a public road, and is there an agreement with the town to take it over, or is it going to be a private road association? Your ordinance may require that they submit, you know, a draft association language, you know, easement or covenant, showing the maintenance requirements for that, et cetera. So all of those documents would be included as part of their application. And the majority of your work as a planning board is going to be done during this stage. So you as a planning board are going to determine that the review criteria under 30A MRSA subsection 4404 is addressed. If there are any lot divisions that require a variance, then they must go to the Board of Appeals before you can finalize and move forward with your review. Once they have submitted a complete application and you've reviewed it against the standards and determined it's complete, then we're going to move to final plan. So the applicant's going to come back to you and have a plan that should be completed and ready for you as planning board members to vote on and sign. And that plan will include any contents of the preliminary plan, as well as any additional items requested by the planning board. So in your, for example, you're doing your preliminary review and you request that they have to have a profile or a cross section of the road. That would have to be then added to the plan, to the final plan. If you had any conditions of approval that were noted under your preliminary review, those need to be updated on the updated site plan. They're going to have lot numbers shown and labeled. The professional surveyor who created the map is going to have their seal on the plan. If they received a variance from the Board of Appeals, the approved variance again must be included and referenced on the final plan site map. And if there's any statements from Maine DEP, the DOT, the State Historic Office, or any other state agencies that's applicable to providing the approval, they would need to be included in that. plan, and then you as the planning board would also have your findings of fact and conclusion of law ready to go so that it's going to be in the town record. And once that final plan is approved by the planning board, the applicant should have 3 copies that need to be signed by planning board members who voted on the application. The first copy is going to be filed with the Registry of Deeds at the county courthouse within 90 days of the approval. And it can be done by either the town or the applicant, and that coordination should be decided prior to approval if it's not already set out in your ordinance. Another copy should stay at the town office so that you have it for matter of record, but also to track the subdivision if there's any amendments that come before you in later years. And then the third copy would remain with that applicant or developer. I will say, make sure that they're not folded copies, have them rolled, because the county courthouse will not take folded copies. So make sure you let the applicants know that as well, so it saves you and them a bit of hassle. So we're going to stop again for questions, because I know we just kind of threw a lot at you. I'm going to stop sharing screen. And what questions do you have for us about the actual review and approval process? Joanna?
What would the showing be for sufficient water? I assume you don't require them to dig a well but
Well,
what
it
kind of
depends.
showing can there be?
They might have to do like a test well. It depends on your ordinance, but they would need something from a well driller saying that there is potable water. Or if it's connecting into public water, they would need some sign off from the water utility to say that it can handle the added capacity.
So we could get a preliminary report from a hydrologist that there is potable water available to this, in this amount. Sufficient.
Right, because you don't want to go through the whole subdivision and then, they sell off the lots and find out there's no water there.
I believe, and I don't know how far back, but all well drillers now have to geolocate their wells and report them.
Do they? Okay.
And that's available on the state website. Well, that's because you're probably not getting good GPS coordinates.
And I see a question from Vet Online. Should all variances requested even for not a subdivision application go to the Board of Appeals? And I think we went over this in our planning board workshop as well. If it's a variance that's talking about dimensional standards or setbacks, lot coverage, things of that sort, then yeah, that needs to go to the Board of Appeals unless your ordinance says otherwise. I assume that's what this is referring to, but you bet you can pop in if that doesn't answer your question. Any other questions?
All right. So we're gonna go through our final slides here, and then we'll open it up for a larger Q&A. Let me just share screen one last time.
Amendment, so you've approved your subdivision application, and then 1 year later, someone says, oh, can I make a little change to this? Maybe make a new lot or change the site plan itself. If that happens, then it should be treated as it's going through the regular subdivision process, or if you have it, the minor subdivision process as well. And yeah, you can create your different tiers so that something like combining 2 lots would go into the minor review, or it doesn't have to go into the review. Redrawing the single lot line, but not changing the number of lots, removing a condition of approval, all those are things that you can certainly have. Just make sure you have it outlined in your ordinance for what would have to go into this different review process. And then just some general recommendations. Make sure you have a detailed subdivision ordinance, and for most of you, update your subdivision ordinance. And make sure it is an ordinance that fits your community specifically. Emily and I could certainly try and put out a model ordinance, but it's going to be a bare bones one, and it's not going to address every single thing that you all think are important to your communities. The fire and emergency services item, for example, that might not be something an average model ordinance has, but you may think it is a very important thing to have for your community, and that is a great idea to have, actually. An example would be that 40 acre lot exemption that Emily brought up a lot earlier. That's something that towns can do. You don't have to allow that 40 acre lot exemption if you don't want to. Then there's the major and the minor reviews that sounds like a lot of you already have, so I won't have to touch too much on that. And then there's also recreation, conservation, open space needs that your community may be trying to address some goals and you want to incorporate into your subdivision review. Also make sure that your ordinance includes the review criteria that is outlined by the state under 38 MRSA 4404. We didn't include all of the criteria on this PowerPoint because it's about, I think, 20 different criteria items, and I didn't want to write them all out, but it is available on the website. It's going over things like pollution, water sources, erosion, traffic, sewage disposal, a lot of things you probably already deal with in your site plan, but these are items under the state statute. The thing I always recommend for site plan subdivisions, have a checklist. Have something that your board will have right in front of you so that you can have a uniform process for every subdivision that goes through. So it's addressing all the same criteria and all the same standards. I also recommend requiring a digital file to be submitted along with physical copies, so it's easier to share those with abutters, planning board members. People may just want to see the application, and rather than you scanning everything and then emailing it to them, a lot of these people are going to be getting contractors and engineers who are already going to have a digital copy ready. So it's just something I think is a little easier to have for sharing. Also make sure you have established your impact fees so that town officials that have to go through this process are properly compensated for it, covering the advertisement notices, if you're doing site visits, or if you have like staff members like a code enforcement officer or a dedicated planner that's spending a lot of time going through these applications, there is some funding that the developer will go through to at least compensate that, even if it's not all of it. And remember that waivers should not be granted just because of financial hardship. They need to have a little more reason to it, like there's conflicts with other standards, like the DOT may like the DOT curb cut item where you can't be on Route 1 if you can access through another point. That would probably be one of those things that they may say, oh, can I get a waiver of this? No, you can't get a waiver just because you don't like the DOT standards. Hopefully no one from the DOT is listening.
I don't see anyone on.
Okay, good. And if a new road is being proposed, as Emily mentioned earlier, have something outlined so that you know who's going to maintain it, whether it's going to be the town, whether it's the developer, whether it's going to be a uniform association. If it's going to be the thing where the lot's going to go to the middle of that private road and up to that middle of the private road, that's going to be owned by that person and they're responsible for maintenance. Make sure they just have that outlined, because 5-10 years after the subdivision is created, that's what people are going to start asking, who's maintaining this road when winter comes along. Some additional recommendations. If the project is requiring town infrastructure, so if they want a public road or they want an extension of utilities, make sure you're gathering some input from any applicable departments and making conditions based on those recommendations. So if Public Works says, yeah, a public road's fine, but this means we're going to have to spend some more time doing this and that, make sure that's incorporated into the conditions of approval if that person wants a public road. Same thing with extending the utilities. Maybe your sewer district or water district doesn't have the capacity to handle 3 new lots for some reason.
And I'm just following along on a Zoom meeting, so I'm happy to look at something too.
That is a fair point. I don't know.
I don't think he realized he was unmuted.
Probably not. So if a subdivision is proposed and they want to be on town water, but your water district says, well, that's nice, but we need to expand the capacity, that could be a condition where the subdivision developer has to help pay for that expansion of capacity. And then that ties into the public infrastructure improvements should be focused at the expense of the developer because they're the reason the expansion has to happen in the first place. You can also look into other types of subdivisions, such as open space and cluster subdivisions. And I think that's going to be a whole nother topic that we probably won't be able to cover today. But this is if you want to encourage more conservation focus in exchange creating some smaller lots compared to what you already have, or subdivision and dimensional lot size requirements. And then just some resources, the three usual people that you'll probably bother when a subdivision comes along. Maine Municipal Association's legal team, you should only really contact them if you have the application presented to you and they're starting to say, the applicant's starting to say, well, this is what we want, this is what we want, and you're not sure about something. Maine Municipal Association's legal team can help with reviewing this and saying, this is what the state requires, we've looked at your ordinance, this is what we recommend. Again, I'm Max Johnstone with the Midcoast Council of Governments. I assist towns that do have some land use ordinance review and requirements that need to be looked over, so I can certainly help with that. For Lincoln County specifically, you got Emily right here. She's fantastic. So you got a lot of resources at your fingertips. So it shouldn't be as scary anymore, hopefully. With that, I think we're on questions.
I have one that's not LD 2003 related.
Love it.
I have lots that are LD 2003
I think
related.
you reminded me now. Loud.
Is it possible to eliminate a subdivision? And how does one go about doing that?
What do you mean by eliminate? Like someone made a 3-lot
Somebody made
subdivision.
a 3-lot subdivision and combine and somebody, person A bought lot 1, person B bought lot 2. Later on, person A buys lot 2 from person B and combines it into 1 lot. So now there's really only 2 lots.
Yeah.
It's still recorded as a subdivision at the registry.
It's an amendment.
Yeah.
An amendment to dissolve the subdivision.
Can you do that?
It's not the dissolve, it's to combine the lots. because-
But now it's only 2
But then
lots,
it's
so it's
only
not
2
really a
lots.
subdivision.
It's doing the same thing.
Yeah, because the whole point of the subdivision is you have land survey laying out, these are where all these property lines are. And now the registry of deeds has those very property lines in their records for what property should be looking like. So the amendment would just be going to the registry of deeds saying, yeah, you can forget those lines now.
Does the subdivision authority lapse after a particular period of time? I didn't see anything in the state.
What do you mean authority?
Well, you get approval for a subdivision.
Right.
And then you don't build it for 20 years. Is there any requirement that it be exercised, the approval be?
I don't think there is. I mean,
Well,
there's,
focus would be that 90 days because once the registry has your subdivision, that's the registry now seeing all the lot lines that should be there.
Forever, whether or not it's built.
Until it's amended again.
I have one other question. You talked about waivers, and the state statute is mandatory that municipality must determine that 1 through 20.
Right.
Where is the authority for waiving any of these?
These would be more of your local standards if you want to expand
If you wanted to waive any of these?
the local ordinance standards. I should have clarified.
The 20 state standards, you can't waive.
These standards in here, we can't waive, but if we added others, we could waive those.
Right, a more local,
Okay.
a local.
Okay. But even a local can't have an ordinance that says we don't want to meet the state standards. These are the lowest.
I think she cracked the code.
No, we had someone who kept arguing.
oh, really?
That they can waive state standards.
Like 10 of them.
Oh, wow.
Oh dear.
Yeah, nope. So we have a question from Jackie online that says, will 2 ADUs on a lot, so accessory dwelling units on a lot with a house, constitute a subdivision?
I assume this is because of LD 2003.
So too.
And, well, it depends how you're gonna have an ADU defined in your ordinance, because I asked Hillary and Ben up at DECD about this, actually. So I believe at how the state has it defined, if you're just having it as an accessory structure, then no, it wouldn't count towards your subdivision count. But if you specify that anywhere else in your ordinance, that maybe you have that in your ADU definition as your town is amending it, maybe you decide to say an ADU for all intents and purposes does count towards a subdivision, then it can count towards your subdivision count. But right now, with how the state has it defined for LD 2003, no, that wouldn't really fall under a subdivision count. Interesting.
Does that answer your question, Jackie, or did you have a follow-up?
Yeah, I know that. Yeah, I know I had a couple turns to get to that conclusion.
I see Mike's hand and then Walt's.
You're talking about amendments, and a moment ago, it was raised this idea of like approval. What I'm wondering is if someone came in, proposed a subdivision, got approved for a subdivision, excuse me, builds out the subdivision. If they wanted to make a change to it, and I'm talking like maybe 10 years or 5 years or even 2 years later, after everything's already been built out, I'm just wondering, I don't think that would be an amendment. I imagine that if someone wanted to do something new, they don't have to go through the whole subdivision process. Like, they don't need to go to amend their subdivision application. They would, if somebody, I guess I'll give you an example. If we had like 4 acres, it was one lot, and then it was split into 3 units, so 2 1-acre lots and 1 2-acre lot. They build out a house on each. Great, it's all done. They meet all the requirements of the subdivision, or of their application. And then a couple of years pass, and they say somebody on that 2-acre lot says, "Oh, I want to build another house on here," whether they want to divide it or not. I would think that would be just a whole new application, not subject to subdivision review. Does that track with? A, did it make sense? And B, does that fit your understanding?
So if someone in that original subdivision decided 5 years down or more down the road that they wanted to then subdivide their re-subdivide their, let's say they're on the 2-acre lot and they want to re-subdivide, is that what you're asking?
Well, but not maybe create 3, so it's not going to trigger subdivision on its own. I imagine if they wanted to take that 2 acres now, the 5 years have passed, if they wanted to create 3 lots out of that, that's subdivision. But if they just wanted to like divide that into 2 lots, that's not a subdivision amendment. That would just be a planning board application, right?
Yeah, that would be.
Yeah, I think it would be.
Yeah. Because it still has to. Yeah, and a lot of heads are nodding here because it's kind of what we were talking about earlier about the evil plan to destroy a 3-lot subdivision and make it a 2-lot subdivision now.
Make it no subdivision.
Make it no subdivision. The lot lines are still at the registry of deeds, and you're now going to create another lot through that original subdivision. So yeah, that would still be an amendment to a plan that was approved by the planning board.
Would it depend a lot on what the covenant said for the subdivision?
No.
That's I guess what I'm wondering is, do you have to go through the whole subdivision review process? Like once you go through subdivision review for, even something like that where you're creating 3 lots, does that mean forever you always have to go back and meet all of the subdivision standards again?
Yeah. I thought it was 5 years.
That's if you're creating a brand new one. Like, we're starting from scratch.
So if you're starting from scratch, that's the 5-year piece. But even if you had, say you owned a lot, let's not even think about re-subdividing the lots. If I was gonna move a lot line in an approved subdivision, I'm moving and I'm adding, you know, taking a chunk from my neighbor. We've agreed upon it. So I'm gonna take a chunk from him, but I need to move my lot line. That would be an amendment, even if it's 10 or 15 years down the road, because I'm changing where the lot lines and the size of the lots that were part of an original subdivision.
Yeah, and again, you can have your ordinance updated for having that more as a minor subdivision review, because that might be something that makes sense to actually go through a more streamlined process.
But if he wanted to build a second house on that 2-acre lot for his mother-in-law, that would not trigger subdivision as long as it stays on the same lot. It would be more like an ADU.
Yeah.
Yes.
But if a subdivision is already in place, they would have to come back to the planning board for that.
Only if they were to sell that second house independently, but if it's for a family member.
Yeah, but
Well,
it'd
family
be
members
another
accept.
structure, so that it would still have to come back.
Well, if it has the family member, that's the.
That's
exception.
easy,
Right.
Yeah. But let's say that you're building a house that's not for a family member. I believe it does, but that's just my thoughts. Again, you probably want to make sure you talk with whoever your attorney is when that application is actually given to you.
It seems to be that if you're building that second house for sale, yes.
Yeah.
But if you're building it as a rental property, for example, where you will retain ownership of the original house on the 2-acre lot and ownership of the second house on the 2-acre lot,
And you still
doesn't
own
trigger, I would think it would not trigger subdivision.
You're not changing the lot lines at all.
Not changing, I'm not splitting it off into a second lot, I'm putting the second house.
and you
as-
still own it.
I still own it.
Okay.
And
Maybe I
just for
don't.
that
I think you would have to have a
elderly
hard look,
additional-
because part of, we haven't mentioned, but part of the subdivision is use counts.
Yes.
Use, not just division of land, but the use of land. If you use it,
But it's being used as a
So-
dwelling unit. So
yeah,
it's-
if you put 3 dwelling units on the same property without dividing it, you trigger subdivision.
Yeah.
Right.
You just don't have lot lines.
So
Did that help answer your question, Michael? Is it okay if we move on to Walt? Because I know he's had his hand up.
Sure. Yep.
Go ahead, Walt.
First of all, to address Michael's question, the final plan provisions of the subdivision ordinance state that any change or modification to any aspect of the approved plan shall be considered an amendment to the plan and shall require approval of the board. So I guess that would be up to the board to decide whether that is significant enough to require them to submit an amendment. Somebody else asked about how long is a permit good for? And most ordinances, and I think the subdivision ordinance also has provisions for percentage of completion within certain amounts of time. And I think it's 30%, and I can't remember the amount of time, but there are provisions for that in that ordinance as well. My question is this: one of you mentioned that where the municipalities have a subdivision ordinance that is not consistent with the state, it is still valid if it is filed within a certain amount of time or filed at a certain place. Could you help me out on that?
So it had more to do with the definition of subdivision. Let me see if I can give you the exact section. So it's section 4401, H2, I believe. And it says, I'm just going to read it word for word.
Okay.
The municipality may not enact an ordinance that expands the definition of subdivision except as provided in this subchapter. A municipality that has a definition of subdivision that conflicts with the requirements of this subsection at the time this paragraph takes effect shall comply with this subsection no later than July 1st, 2019. Such a municipality must file its conflicting definition at the County Registry of Deeds by June 30th, 2018 for the definition to remain valid for the grace period ending July 1, 2019. A filing required under this paragraph must be collected and indexed in a separate book in the Registry of Deeds of the county in which the municipality is located. So I actually misspoke, as they were giving you a grace period, but they wouldn't allow you to amend it indefinitely. So it looks like we have a lot of writing to do for all of you for definitions of subdivision ordinance.
Thank you.
Ours was 20.
Good. So we had a couple of questions in the chat. First is from Melissa Allen. She asked, did I hear you correctly when you said that a municipality can define their interpretation of an ADU? Max, I think that was going to your original question.
Yeah, so I think the ADU is more of an LD 2003 question. But while the state does give you a definition of an accessory dwelling unit, it does not have to be a word for word copy into your ordinance. You can certainly amend it to fit with the rest of your ordinance. So for something like the subdivision question that we had just a moment ago, if you want to include a little snippet into the definition that just says an accessory dwelling unit would count towards the subdivision, or if you want to have that more in your standards or in your subdivision ordinance itself, just saying an ADU would count to it, you can certainly do that.
And then we also have a question from Jen Merritt in the chat. She says, what about when you sell the houses on the subdivision? Does that not mean that the new owner brings any changes to their lot, home, or added home to the planning board themselves? So Jen, I think what you're asking is when after the original subdivision and each lot sells off, is that new owner responsible for going to the planning board? And the answer would be yes.
And what I meant also with that was, does that change when an amendment might be required?
Oh, so are you asking, like, does it reset a 5-year, or because the amendments kind of run with the land, so I don't know that even if you, so for example, kind of what we were talking about earlier, if someone came in, 10 years down the road and was to change the lot lines within that original subdivision, it would still be an amendment versus like a new subdivision.
So it would involve both the subdivision owner originally, or the developer originally, plus the owner?
No, it would just be the new owner applying to amend the original subdivision.
Okay.
Because it's the planning board's approval that would grant it.
So another question then would be, will the new owners, would the people who buy the property in the subdivisions, would they then have to maintain files of all the information for the full subdivision so that they could then request amendments?
That's why the recommendation we had was that the town holds on to a copy as well as giving it to the developer, so that if the developer decides to just sell the property and leave, that could be something that's given in the sale of the property. Or if the developer decides to just run away with the plans, the town does have a copy.
Okay, so most people don't have a clue that they might in the future be responsible for an amendment, as well as all of the other planning board requirements to any changes to their properties. And so that would be something I would say has to be required, that a developer share that information in the sale. I know we can't tell everybody what to do, but that tells me that people who are buying it wouldn't have you know how it is. People come in all the time, buy property, they don't have a clue about ordinances, they don't understand. So just a thought for the future.
Michael, I saw your hand was up and then it just went down. Are you?
It was kind of along those lines of, like, I've noticed that there's no process for approving not subdivisions, but just splitting of land. So, and I just wasn't sure if anybody had a good way of dealing with that, since sometimes people split land and then a couple of years later split it again, and then maybe a year later they split it again, and it should have gone through subdivision and they've built a house on it. No one's caught it. It's kind of there's not a good kind of catch, which I think is what Jen was also talking about, and I gather that maybe there isn't a good catch.
I unfortunately don't have a good process in mind, but that is kind of one of the reasons why it was noted earlier. You have until 20 years to catch one of those types of violations and then go back and say, well, all of this was done and it never got approval, so you got to get approval now because you are a subdivision. In terms of
sorry, Max, who would be responsible for that if you catch it in 15 years, for example? Who would you be then going after when property might have been sold and resold?
Usually most current owners.
Yeah, that's, again, I'm not anyone's attorney here. But that would be something you just have to notify almost every owner at that point that's in that subdivision. And then work that out with the code enforcement officer and the local owners as well.
But I think it would mostly be it would be a new owner's headache, I believe.
Yeah.
Carl?
Well, on that one, that is, for me, that's happened several times, and you know who catches it? The title company.
The who?
The title
Oh, the title company, yeah.
They're gonna look and say, whoa,
And they're not.
we don't see it, we don't see an approval anywhere on the record.
Yeah.
A lot of planning boards probably still think they sign a plan, they're done. You mentioned briefly a document, it needs to be signed with it.
The finding of facts and conclusions of law, yep.
You wanna go over that? Because I'm not sure everybody here knows that.
Sure, so hopefully you've been, and I know we talked about it a bit at our planning board workshop back in June. I think it was June or, no, that was LD.
I think it was like February.
Maybe it was February. It's
Yeah,
recording.
It was a few weeks ago.
There is a recording that we can share out with you, but essentially part of the responsibility on the town's part is to have documentation explaining, justifying your decision to grant the approval, which is the finding of facts and conclusion of law. So you are going through the subdivision standards and addressing how the application has met those standards, or if you granted a waiver, you know, what your justification was for granting a waiver from some of the standards. And that's something that's important to have on record. Again, if there's ever a question about it from maybe an abutting property owner, or even someone that's buying the property 20 years down the road and just wants a full copy of the approval process that went into this. So again, it's something that if you have a planner on staff, you could utilize them to put together. If not, you know, someone on the planning board would have to tackle the writing of that, but you would want to go through each standard and write your justification, but also, you know, as you're reviewing the overall approval, what some towns will do, and it's probably a good thing to do, is take a vote on each of those standards and then record it in your finding of facts and conclusions of law. Mel?
If there's an error in the conclusions of law, they stated something which was not technically correct. That passes, things go on. And now somebody raises a hand and says, hey, you were totally wrong about that. What happens?
I think I need a little more information for the hypothetical to be able to give you a hypothetical response. There's a whole host of possible errors that could be made. And so it depends on like, what is the error, if you will, in terms of what the solution is.
Is this like a spelling error, or did the conclusion of law say that the planning board approved a 4-lot subdivision, even though it was only a 3-lot subdivision?
Right.
Something serious that would upset the, yeah.
Unfortunately, the conclusion of law is meant to be the thing that the planning board's kind of overall approving for that type of document. Hopefully you don't make that error.
Another quick question. Is there any provision in state statute for essentially terminating the existence of originally approved subdivision? Say all of the lots are back in a single ownership.
That's what I was asking.
Yeah. Can you have a final amendment that says, you know, we're back as a single lot of record?
And then 2 years from now, they just try to split off a lot. Obviously, you wait 5 years.
Yeah.
You should be good at that point. But
Right.
when does the subdivision die? If everything reverts to one ownership.
Yeah.
Am I stuck?
I don't know that it resets. I mean, I don't know if it resets the clock. When you say you've merged, your final amendment is to merge all the lots back into single ownership, and you've dissolved all of the other lot lines. So it goes back to what it was, say, 15 years ago.
Right. And 20 years from now, somebody wants to split a lot. Is it a subdivision, the original subdivision, or is that subdivision gone away?
I think it went away.
I would argue that it went away.
I think.
I'm not a land use attorney, but I would argue that it went away.
And I would say there should be a plan recorded that shows the whole lot and a note saying purpose of these plans to eliminate subdivision created by blah, blah, blah.
Right.
Blah, blah, blah.
But that's just the procedure you went through,
Right.
not something
It's
that is.
recording the fact that it has been wrong.
So is that a de facto or a de jure maneuver?
I'm okay.
It's not spelled out. You're amending the subdivision to eliminate the subdivision, basically.
Yeah, I'm not familiar with too many cases where someone will
And
create.
I would say that resets the clock to them.
It probably does, but I just don't.
I
don't know if there's been like, I just don't think there's been like a case like that that's happened too often, where someone goes through this process to make multiple lots, only to then get rid of it a few years later. So, or someone decides to buy all those lots a few years later, get rid of the entire subdivision, and then someone will make it.
It happened in Booth Bay, and I don't know what the end resolution was, but somebody bought a subdivision, bought the entire subdivision.
And then merged it all.
And then merged it all back. But I don't know what the final disposition of the subdivision was.
Okay.
In North Newcastle, we have one ancient subdivision that, no, I don't believe any lots were sold off, and then the corporation that had crafted this, got approval, then went out of business. Don't know what the outcome is, whether those lots on that ancient plat still have any meaning or whether they are null.
Well, the company went out of business, but they didn't.
Right, the property went to somebody.
Probably went to somebody else, but the corporation that created the subdivision went out of business.
Well, if it's ancient, prior to 1971, it's not a national subdivision.
Well, that wastes time.
It's about in that time.
Oh, well, you're gonna put it on the.
Was this that subdivision that's in the middle of the river?
No. It's in the, it involves a good sized swamp and river boundary, but not in the river.
Monday.
Glenn, I know your hand's been up for a while. Would you like to ask your question?
This is, I'm almost forgetting what it was. It was referencing something that came up earlier. God, it slipped my mind now. My comment on getting rid of subdivisions. The only way you can get rid of it is you have to file it through the registry of deeds that it ceased. If the title attorneys can't find that things changed through the registry, it doesn't happen. So once you created it, you have to make it disappear in the registry of deeds so that they can find that trail and go forward from there.
Great, thank you, Glenn. If you think of your question, please.
We got time, don't worry.
Yeah, we have time. I'm gonna go to another question. I see Michael's got his hand up again, and Glenn, if you think of your question, let us know.
Yeah, sorry, I'm going to continue to kind of maybe beat this horse. It's not sitting right with me that you approve a subdivision and then it's just kind of locked in for perpetuity. I'm just wondering if there is is there some way that it can be kind of a gate that someone comes and says, I want to split my lot into 5 lots, and then you're like, yeah, great, go ahead, and they split into 5 lots, and then some time passes, 10 years pass, that then it can just go back to being 5 lots that are, however large, and if they want to do something on one of those lots, they don't have to go through the subdivision. So they never sold them off or whatever it is. I'm wondering if it can be a gate rather than like this forever structure. because my limited experience with municipal governments is sometimes records are not amazing. And I'm just wondering if like this can be kind of like, yes, you may do the things that are included in this subdivision approval. And then once you've done those, that's it. Now you're back to square one, and anything you want to do, assuming the 5 years have passed, that original 5 years for a subdivision, once those have passed, I'm not sure why we need to keep them locked into or prevent them from doing anything new with the land, assuming they meet all the other ordinance regulations. And so I'm just trying to figure out if there's some way that we can, not burden the properties, but also keep things regulated. I don't know. It doesn't seems like in 20 years, nobody's going to care what was approved 20 years ago.
I was going to say, welcome to subdivision law. It makes no sense. One thing I will say though, yes, in theory, it feels like, this shouldn't be an overly burdensome process for applicants, but the one thing you have to keep in mind is that subdivision runs with the land. So it's there in perpetuity, including if there's conditions of approval or covenants that have been placed by the original developer. So that's one thing we haven't fully covered here yet, is if there are covenants that are tied with that subdivision, for example, that properties cannot be more subdivided in that subdivision, that's something that's going to run with the land forever. And so it can't expire unless that's put in the covenant that it expires after 20 years, for example. So while I understand and sympathize with your point that, an applicant 25 years down the road who doesn't even know they're part of a subdivision is going to be in for a rude awakening when all they want to do is re-subdivide their lot. It's really like a case-by-case basis based on whatever was part of the conditions of approval of that original subdivision. So I don't know that they'd ever be able to leave. It's like Hotel California. You're there forever.
Okay, I understand. I don't like it, but I understand.
Again,
So
welcome to subdivision.
Yes, yeah.
Talk to your legislator, get them to change the law.
Glenn, I see your hand came back up. So if you thought of your question, please go ahead and ask it.
I remembered what the comment was for. If you go back and you find an after the fact subdivision was created, all the current owners of the property involved in that have to co-apply. They all become applicants in the request for the subdivision. It has to cover them all. If the original owner is long gone, that owner's long gone.
Great, thank you, Glenn. Carl, was your hand up?
Yeah, only in that for a long time, and it's still hanging around, the 5 year, it goes away in 5 years. Was around, and it's still great to some towns. It's one reason our town made it in there. No, it never goes away. 200 years from now, if you want to move that line, you have to come to the planning board. So this will still be there.
Well, and I mean, we have one in South Bristol that's 5 lots. Lots 1 through 4 are owned by one person, and the 5th lot is owned by another one. And the reason they want to keep it as subdivision is because they want to keep the covenants on
the 5th
lot 5.
Yeah.
So we have, how many lots are there?
80.
80?
I think there's 80 lots in there.
So within the covenants of that original subdivision is the provision that each lot can be split once by the owner.
Within a minimum lot size of, they're all 10 acre plus lots. And
Okay.
minimum lot size, one of the split lots has to be 3+ acres.
Okay.
So we don't even review those really, or it's just a pro forma because it was approved at the very beginning of the subdivision.
That split would be allowed.
Yes.
That split would be allowed.
Actually, we have to approve it because it's written in their covenant. The planning board has to approve
The split.
the split. And we've had some iffy splits where they're like 2.96 acres or 2.9 acres because there's a road that exists between them.
Mhm.
So, yeah, and how old is the road and when was it built? So that was our first adventure. We've split 8 of those lots already in the last 2 years, so pretty interesting.
Yeah.
And it causes it's gonna cause a problem with water, because everything on Westport Island is well. So it's a big issue.
But I'm sure it was a selling point for the original buyers into that
Yeah.
subdivision. You know, you've got this commodity you can always sell.
So how's this all play with LD 2003?
Now, you had that question earlier.
I forgot that one.
Well, with all that ADU talk, I figured this was gonna come up. Mal, you said you had a question that was probably gonna be more LD 2003 focused. Was that a question that's come up at some point, or is this different?
I think it's been covered or confused at this point. My biggest concern is the perpetuity issue. Is that a hard and fast either element of statute or of what's worse of legal interpretation might actually override what the legislature is actually able to do?
When you're talking, so if there's, I want to make sure I'm understanding you. So if you're applying LD 2003 to the perpetuity piece, or is this a separate question?
This is subdivision. In other words, if it really is, once it's created, extant in perpetuity.
Unless you go for an amendment to amend your covenants. You can do that too. You could apply, I think I don't remember what slide we covered that on, but part of your amendments can be to change conditions of approval. So if there, or you could try and amend covenants.
Remove all restrictions that had existed throughout the history of the subdivision? Can you actually end up with just a single lot of record as the outcome without any ghosts from the past still binding the thing, this area of land that once was a subdivision?
So I would think it would be part of your, is going along with what Bruce had asked earlier about like basically dissolving the subdivision through an amendment. You would also have to request that you're dissolving any sort of subdivision conditions, or if there was easements on the property or any sort of covenant restrictions. You would have to dissolve all of that to create it back to a blank slate, if you will.
That is possible. As you
I would
see it?
think so, but again, I'm not a land use attorney. So I give that caution only because I've seen in practice that I've gone to planning boards asking for these things to be removed. Sometimes, depending on like what it is, you've had to get agreements where everyone in the subdivision has to go to the planning board to get it removed. It can't be just your lot.
Assuming that it's all in the same ownership at the current point in time.
So if I bought up all the lots in the subdivision, I essentially wanted to dissolve it, then yeah, I would be the one going as owner of all 6 of those lots, say, back to the planning board to ask that they remove whether it's a condition of approval or a covenant and have it dissolved. And then you would be filing it back with the county, with the registry, so that it shows up on a title or no longer shows up on a title.
So it is possible with the engagement of the local planning board.
Yeah, you need planning board. If planning board approved it, you need them to approve getting rid of it too.
Thank you.
Mm-hmm.
So you had an LD 2003 question?
How do they play together? Do they play nicely with each other, or are they at odds with each other? I mean, it seems to me there's lots of things in here that don't necessarily play well.
So,
They're not compatible.
Yeah.
So minus that accessory dwelling unit bit, again, this was another question I wanted to ask Hillary and Ben from the state about this. So one of the things everyone loves from LD 2003 is the number of dwelling units you can do in a growth area. You can go up to 4 units. if I recall correctly, in the guidance document that they sent out, they do specifically say that LD 2003 is not meant or should not be intended to circle around the subdivision law. So, well, hold on. So if we go back, so the definition, if we go back to that, that was talking about, you take because we always keep talking about the lot being split, where, if you have a 10-acre lot and you split it into 3 lots, or 9 acres, and you split it into 3 lots, 3 acres each, that's a subdivision. But that also includes if you have a 10-acre lot and you just put 3 new buildings on there, that's still a subdivision as well. So that's the same thing with LD 2003. It has to be in a growth area, obviously, but if I have that undeveloped lot, I'm putting 4 units on it, that's a subdivision. That still goes through the subdivision process. It doesn't circumvent it, it still just has to go through.
3 or more.
3 or more units. I'm just saying, what did I say, 4 units?
Yeah.
3 units, I'm sorry.
Even if they're ADUs.
For ADU, you should specify that in your ordinance. Because, or
If
at least,
those are outside or inside.
well, I just say in general, because I think the state has accessory dwelling units being more of an accessory to a structure. So maybe talk with the attorney when you are updating your ordinance on that, or just have a clarifying line that says this is meant to count towards subdivision. Because an ADU is a bit of a gray area for a lot of people, so it's best to clarify. The regular dwelling units, that's something that definitely would go through the subdivision process. And let's see, who do you want to have first, Jen or Mike?
Well, we'll go Jen, because I think hers is tied, and then we'll go back to Mike. So Jen said, okay, another question. If you build ADUs on your property but do not sell them, is this still a subdivision, meaning 3 or more?
Yes. Yes.
So the consensus in the room, Jen, is yes. Mike, your hand's up?
Yeah.
In general,
I just want to make sure I understand, because the definition of subdivision I'm looking at does include the 3 or more dwelling units, but I'm thinking that's an old one, right? Is that probably the case? Because now subdivision does not have to, like a division of a building into 3 or more units is not a subdivision. Is that right?
Correct. It's a weird one. So if you have a single building that's split into 3 for residential uses, that's not a subdivision. But if you have 3 individual buildings and each of them are going to be dwelling units, that is a subdivision. Yeah, wrap your head around that one, Mike.
But how does that not fall under apartments? Under the subdivision, or condominiums, or?
Condominiums have been treated as subdivisions up to now.
In some places.
Well, that's why it was treated as a subdivision up until 2018. I think the reason was, I can only speculate why that change happened, and it might have just been that apartment building, multifamily apartment buildings, a single building, already goes through a site plan process. That might be it. I can't speak for the state legislature. So yeah, if you,
This isn't a question, it's a comment. One's head can hurt in this game. And some of us would just love to go back to Crato. You remember him?
So Jen asked the follow-up question of common walls, so townhouses with common walls. So Jen, I think what you're thinking is going, instead of going vertical, go horizontal. So they're separate unit. Okay, yes. I'm not sure how they would handle it, because I think it depends on how you design it. And if you have an architect who knows how to circumvent the system. So it would be like 3 like this instead of,
I mean, if it's all
3 like this. But if it's all contained within the same walls and it's one footprint structure, I think it's the same.
right, if it's a single structure that has the 3 dwelling units inside of it, then it's a multifamily, unless someone has a different definition for multifamily dwelling unit. that would be a multifamily dwelling and it doesn't go through the subdivision process.
Yeah, so can we be looser? I mean, it seems like the simple solution that I don't know how this law didn't get at is like, if you're dividing land, subdivision, units don't make subdivision, but that's obviously not what it is. So I'm just wondering, can we do that?
I think what they put into place here is they're saying if you're putting up a building for multifamily housing, you have multiple apartments, multiple townhouses, with no intent to divide the land, it's the land ownership remains as one, but there's multiple people living there. They're saying that's not a subdivision. If you want to divide the land with separate structures or what have you, then yes, it is. But if you want to have these large multifamily dwellings, whether it's townhouses or apartments or what have you, they're saying that's okay as long as it stays as one parcel. You treat it as a development, not
one
as
parcel,
subdivision.
One parcel with 3 buildings is
Right.
subdivision.
Well, with one building with multiple units in it.
No, I'm saying with one parcel with 3 buildings is a subdivision.
You
Even though it's all
could divide
the
the
same.
land.
No, when you're not dividing the land.
But you could.
You could.
Yeah.
And I've seen it happen.
Well,
and then
there's nothing stopping anybody from dividing the land and not telling anybody, as we've noticed already.
Yeah, that's true.
So,
How does that fit in to accessory dwelling?
Mobile homes?
Mobile home park.
Oh, boy.
That might be subdivision 102. That might be our next one. Yeah, 200 level course. Because there is a mobile home subdivision definition, which is separate from this.
Actually, I'm curious what Ben and Hillary would have to say about accessory apartments and mobile home parks.
Yeah, I would too. Right.
I know, at least in those cases, there's hardly any difference between our site review and our subdivision reviews. Like, I'm working to make them not different. Most subdivisions trigger both. There's a road that triggers site automatically, so usually. So the differences are fairly minor. And for years now, we've told developers, title plan, subdivision, and site plan review of S-road subdivision, whatever it is.
So have we melted your brains enough, or are there any other questions? Anyone else on Zoom have any questions?
no, I just want to say I appreciate all of the conversation, but I still want to just go on the record saying that this law could be improved.
Really?
I think there's general consensus here with you, Mike. All right, well, thank you so much for joining us. We appreciate it. We do just want to give a plug that if you have any topics or areas of interest that you'd like Max and I to come up with a workshop on, please let us know. I think we're aiming to try and do these quarterly. So if you have suggestions, we'd love to hear them. We're trying to schedule something on shoreline zoning, hopefully before the year's end or early 2024. But if you have anything else that you'd like us to cover, by all means, please let us know, and we hope these workshops have been helpful for you.
Thank you for your brave attempt to illuminate the inside of the box.
Great. Thank you so much, everyone.
Thank you.
Thank you, everyone.
Thank you.